Hi, it's Mike DelSignore, and I'm in my office, and I've been trying to go through all of my CDs during this slowdown coronavirus. I have a pile of CDs here that I bought from the National College of Criminal Defense, National DUI College. Pretty much any organization that's teaching criminal law, I buy their stuff. But anyway, I wanted to talk about a lecture, probably the best lecture I've heard in a long time. And that was a lecture that I listened to. It was from the National Criminal Defense Association's uh, fall meeting in Philadelphia, and it was Dyke Huish that spoke about the psychology of persuasion. And I picked up a lot of different nuggets that I can use. And I was thinking about this. I actually listened to this lecture a few times, so I wanted to share that in this video. So one of the things he talked about is the language we use, making sure that we're very conscious of our word choice. And one of the things he mentioned is when you can frame it as an interpretation, use the word interpretation, goes a long way to reasonable doubt. So we want to stay away from words, he said, like facts, and we want to get the jury thinking that everything is just an interpretation. So a lot of us defend a lot of DUI cases. I know that's my primary focus. We handle a ton of DUI cases here. And the word interpretation suggests reasonable doubt. And DUIs are all about interpretation. You know, the officer's saying that your client was unsteady on their feet, and their interpretation is because it was because of alcohol. Well, it could have been a lot of things. It could have been the person was nervous. They weren't really sure how the officer was judging these tests, how strictly things were going to be graded by the officer. They might have had a knee injury or back injury that the officer can't know whether that had more to do with their performance or alcohol. So we have a lot of ways we can use that word interpretation and show that things are really subjective in the DUI context, especially with the way the observation, the person fumbled for their license and registration. We see that often. Well, the license, it's stuck in that little plastic container in the wallet. So yeah, it's meant to be difficult to get out. So is that fumbling for it? Is that you're just taking something out? So that's their interpretation. It's not a fumble. They didn't drop anything. They weren't all over the place. They're just normal difficulty getting something out of a place that it's not meant to be gotten out easily. Another place you see word choices, you'll see the officer say something fell off the line on the 9-step walk and turn. Well, you ask the person, well, they didn't fall, right? And they just put their feet were slightly off the line. So I like that. When you get something like fall off the line fell out of the instruction stance. I think you got an officer that's overstating, exaggerating, and you can show that the officer can't be completely trusted in their description of things. So all about interpretation. I like that. Great word he used. He talked about some other things. One of them he mentioned is that we got to deal with what he called the cognitive dissonance, that we're representing somebody that the jury, and on charges sometimes, that the jury instinctively is going to be repulsed by. I have a few indecent assault and battery cases that I'm preparing for trial, and that's what we have to do, is we have to address that. And I like how he did that. He said, nothing worse than these charges, nothing worse than someone doing these kind of things to a minor, but equally on par with that is someone being wrongfully accused of these crimes. And he again, with word choice, he said they had a case where they really spent a lot of time thinking about word choice, and they said they described their client as truly innocent, and he thought that extra word really put more gravity into it. And I've heard in other seminars, Tyrone Moncrief, good friend of mine, he great lawyer out of Texas, speaks all over the country. He does that with a story where he'll say, he was picking up his child. They didn't know him at the daycare. He was his wife normally picks up the child, and he had to pick up the child, and they asked for identification, and he said, you know what, I wasn't upset with them because they were protecting my child. They were protecting kids, and that's what we do as a society. And he said, when you heard that charge, you were repulsed by it because that's what you did. You protect your kids. So it's a great thing to think about, is how are we going to deal with the emotion in the courtroom. And he had some other really interesting ideas about sort of recreating a standard. And so what he would do, he would make he talked about what he called the concession followed by a but. So you have a police officer on the stand, and the case is really, you got to attack the cop. You got to go at the cop. You say the cop is a dirty cop, so to speak. And he'll say, so he framed it this way as, police, protect us, they're serving us, but our task today is to decide if there's a rotten apple in the bunch. That's how he framed it. So you can lighten sort of, he likes to use a but or however to sort of lighten the attack on something that the jury will instinctively find difficult, like attacking a police officer. He had another really good idea, what he called the illusion of superiority, where the jury thinks they have everything figured out. And how do we deal with that? And he says, he likes to frame it as questions. We're here to explore, solve, discover. And he likes to use those words in opening statement to keep the jury's mind open and to deal with that fact that most jurors think, this is something that they understand, they have all figured out. That you have a guilty guy in that chair. So it was a terrific lecture, very inspiring. I highly recommend it. There was one other point that I want to mention about, we call it the principle of the macro and the micro, and that when we break things down to their smallest parts, they either seem bigger or smaller depending on how we want to frame them. So you have a client that is giving you a hard time about doing a long jail sentence. Well, break it down to how many days that is, and that's going to give the person a different feel about how it seems. So he and just to close on this, he says, you want to choose your roles, like how are the jury going to perceive you as a teacher? They're going to be do you have to be more confrontational, like a television lawyer? What's your role? Because if you don't choose your role, it'll be chosen for you. So we want to control the dialogue in the courtroom, control how they're perceiving us, how they're getting information. And I thought the lecture was tremendous. It was both helpful to incorporate into my practice, and also very inspiring as well. He ended the lecture very uplifting. He's a truly gifted attorney and speaker, so I highly recommend it. I wrote a blog about it, and I also talked about it on my podcast, What's New in Criminal Defense. If you ever want to talk about criminal defense, feel free to contact me. I'm on Facebook, Twitter, all the social media. If you're a lawyer, if you have a case, you can call. Anybody can call. Love doing this job and be glad to talk to anybody. 781-686-5924, my personal cell. Have a great day, everyone.